have got a situation coming out. I'm sure you guys have heard the Rahimi case was just released, but the first thing that I come in, I want to know what it did to the Bruen decision, and I want to know what it did to the red flag laws. This is something that we need to dive into. As soon as you guys get in here, I will go into it because I got a few segments here which are interesting from this decision. So this is something that I think is extremely important to know. I'm going to dive into a lot more as the day goes on, but off the bat, I'm going to walk you through that here in a second as we dive into this, because the big takeaway here was kind of twofold. First takeaway was, did they actually side with us or against us on the Rahimi case? The second takeaway was, if they decided against us, what did that do to the Bruen decision? Because the Bruen decision is the big one. So that is the important thing we're going to dive into. As soon as you guys get in here a little bit more, I will hit that. What up, Junkyard? Ohio in the house. I love it. All right, beautiful people. Got notifications coming in all over the place. What the duck? All right, so let me just walk you through this a little bit, guys. It's going to be a very high level live stream real quick. But effectively, it looks like they did not touch the Bruen decision in this ruling. So the Rahimi case did come in, and they sided against Rahimi. So effectively, they said that a government, through restraining orders, can disarm an individual. That's effectively what they said. Now, this is very important. How they said that is the key point, because as they go through this, they basically thread the needle of, it looks like, keeping Bruen the same way and not changing the history, text, and tradition, which was the goal of the left. The left wanted this destroyed, okay? They didn't get it, but they did get the Rahimi here. So let me run you through a couple things that I just noticed. I'm just going to read them to you because I'm working off my computer. What's up, everybody? All right, so this is what they held, and this is important. When an individual has been found by a court to pose a credible threat to the physical safety of another, that individual may be temporarily disarmed consistent with the Second Amendment. Now, right off the bat, I see red flag laws on that one, but we'll talk about that in a second. Since the founding, the nation's firearm laws have included regulations to stop individuals who threaten physical harm to others from misusing firearms. As it applies to the facts here, it fits within this tradition. That's what they said about the Rahimi case right now, okay? Says audio is no good. If it's a little echoey, I'm in a room I'm not used to being in. Sorry, guys. So let me walk you through one more thing, because this is just off my phone. As we explained in Bruen, this is an important piece. This is a very important piece. As we explained in Bruen, the appropriate analysis involves considering whether the challenged regulation is consistent with the principles that underpin our regulatory tradition. That's key, because what that means is the Bruen decision is in place. It is here to stay. That's what they're saying there. That's the existing standard. That is the standard going forward. Okay? Audio is good now? Excellent. A court must ascertain whether the new law is relevantly similar to laws that our tradition is understood to permit, applying faithfully the balance struck by our founding generation to modern circumstances, discerning and developing the law in ways a commonplace task for any lawyer or judge. What they just said in this part, and again, I'm only working my way through it, they're keeping the Bruen decision as it was, no questions asked. That's the point. So if the Bruen decision stays in place, the left lost, because what the left wanted to do was they wanted to use the Rahimi case in order to undermine the Bruen decision. That's not what happened here. Now, they did win on the Rahimi case. If you're a domestic restraining order, which again is no conviction, you're going to lose your gun rights if there's a motion against you. But they did not destroy the Bruen decision. Again, I'm going to work through all this as we go forward, because this is a long decision. But this was something that we've been waiting for. Excuse me. Nevertheless, some courts have misunderstood the methodology of our recent Second Amendment cases. These precedents were not meant to suggest a law trapped in amber. As we explained in Heller, for example, the reach of the Second Amendment is not limited only to those arms that were in existence at the founding. That's solid. Rather, it extends prima facie to all instruments that can constitute bearable arms, even those that were not yet in existence. Again, reaffirming Second Amendment. By that same logic, the Second Amendment permits more than just those regulations identical to ones that could have been found in the 1791. Holding otherwise would be as mistaken as applying the protections of the rights only to muskets and sabers. So what he's doing there is he's trying to walk the balancing act of saying, well, yes, some restrictions are okay, but also you can't get rid of the Bruen decision. That's the point. Again, this is all me just going through this off the top of my head. By that same logic, the NFA is illegal. Brandon, that's a very good point. That's a very good point indeed. But that's all of this is going to come into its own here pretty soon, probably in the near future. But someone just said the clarification is huge. Yes, the clarification is huge because now the left can't say, oh, well, we're not historical agents, we're not historians, blah, 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 blah. That's not the court. This is a mockery. All the attacks that they were doing, they don't have the same attack pattern. Look at this from the 50,000-foot view. The left did not get what they wanted on this. Anyway, let me show you one more thing here, and then I'll kind of break it down with you guys. This is from the actual Justice Roberts' decision, because he's the one that delivered the opinion, so that makes sense the way this is worded, trying to aim at the middle, because Roberts doesn't want to make anyone mad. Chief Justice Roberts delivered the opinion of the court. A federal statute prohibits an individual subject to a domestic violence restraining order from possessing a firearm if that order includes a finding that he represents a credible threat to the physical safety of an intimate partner or a child of the partner or individual. Respondent Zaki Rahimi is subject to such an order. The question is whether this provision may be enforced against him is consistent with the Second Amendment. Now, this is where it pays off, because there's like three things that I was looking for on this. Rahimi was a horrible case, you're correct. So I'm going to close this for a second. And I'm going to do a lot more of these in the future, because there's a lot of stuff in this. But you have to understand there were three things that we were looking for in this case. The first thing that we were looking for is, are they going to side with Rahimi or are they not going to side with Rahimi? What does that mean? From a political fallout perspective, what that would have meant was if they sided with Rahimi, then the left would have marched along and said that the Supreme Court is out of step, they're extreme, they're MAGA, they're insane, they want felons and they want violent people to have guns. That's exactly what they would have said. It would have been a political trap. So they didn't side with Rahimi. So the Rahimi piece did not get it. Now, I'm going to save my opinion on it in a second, so I'm not siding with them. This is a very interesting outcome. The second thing, in my opinion, personally, the left lost on this one. And the second thing, but so did we kind of. It's a weird feeling I have right now. The second thing, they wanted to go after the Bruen decision. They wanted to go after the Bruen decision hard. They wanted it reworded. They wanted it reworked. They wanted a lot of things on this to say, hey, we don't have to have this history, text, and tradition because it's stupid and we don't need it and we're not historians. That didn't happen. They kept the Bruen decision in place. That's a good thing for us. The third thing on this, and this is the part that I really am concerned about in the future, and there's going to be more litigation on this, red flag laws. So the Rahimi case had elements that were similar to red flag laws versus the restraining orders, okay? So the fine line there is the domestic violence restraining orders were granted by a court based off of what Roberts was saying was evidence of threat to other people. That's what they're saying. Red flag laws are around the assumption of, well, maybe if they could and it's concerning, we should probably just take the guns without due process anyway. Now, the interesting part about this is, if you look at the red flag laws and you look at the domestic violence restraining orders, they are very close, they are very similar, but they are very different. What this just did was this outlawed or ruled out one of the portions of red flag laws where they were being so careful around saying, well, it's perfectly fine and legal because it's for safety. But domestic violence restraining orders are actually system-built items that are in there already with due process built in. That's the idea. That's what they're going to argue, right? Personally, my idea on this, from what I've read so far, you're going to have left be meh, right be meh, and you're going to say, okay, well, now let's talk about red flag laws. So the Bruen decision is still in place, which is excellent for us. But you're going to take people's firearm rights without actually convicting them of anything. That's bad for us. But where does this leave us on red flag laws? This is a very interesting thing. I'm going to break this down a lot more. Let me look at the chat real quick. Yeah, there's already background checks. So it went the best way for the Second Amendment in future cases. That's a good question, Peter. I have to read the entire thing to say if it went the best way possible. I can tell you this on a high level, and this is kind of where I'll wrap it. High level, it did not go the worst case as possible because the Bruen decision was not destroyed and it wasn't reworded and it stays as is. That Bruen decision is what the left wanted to destroy. So that's a win for us. Now, people having their gun rights taken away without a conviction, That's not a win for us because that kind of reinforces the red flag law side of things. But then it leaves more questions and clarifications. And honestly, in my opinion, brings more impetus to the idea of, are red flag laws legal? Are they illegal? Do they avoid due process? Are they a violation of the Constitution? That's the one that will be the thing. So I can see conceivably in the future that they come down and they say, well, domestic violence restraining orders are upheld by the Supreme Court for disarming people through the Rahimi case. But now we're going to put something out for red flag laws around you have to have due process or you can't do them. That's what I would expect to happen in the future. But the case just broke. That's kind of my initial gut feelings on it. Of course, we're going to hear a lot more about it as we break it down and analyze it more. But thank you guys for watching. I just wanted to bring it out there and kind of show you my high level observations. And I will see you on the next one. I'll probably dive into this some more.